Okay, good morning, ladies and gentlemen. Thank you for coming along to what is an interesting issue, shall we say, in the data protection world. GDPR is changing at the end of this year. That's certainly the plan. And what I'm going to take you through this morning is literally take you through those changes, but more importantly, how this impacts on your business. I'm just going to turn my own screen off for a second. Mute that, sorry. Turn my camera off. So I'm hoping everybody can see the screen and everything. Come through on the chat if you've got any questions to start with, but we will be doing Q&A at the end. So, Allott and Associates, a little bit of background. My name's Philip Allott. I'm a qualified GDPR practitioner. I have a law degree. I'm an acting data protection officer for 2 organisations. I'm also the managing director for Allott and Associates, and one of our specialist areas is GDPR data protection and compliance. GDPR post-Brexit. So, as many of you will know, we actually left the European Union formally at the end of last year. However, we have been in sync ever since, and data protection is a good example of that. So GDPR so far this year has remained entirely in sync with the European Union, as indeed has most other regulations. At the end of this year, on the 31st of December 2020, the EU will classify the United Kingdom as a third country. That will have quite interesting ramifications. It means that GDPR will no longer be, the GDPR standards that you have within your businesses will no longer be recognised within the European Union, and to be precise, the EEA, because GDPR covers the EEA as well. Now, the United Kingdom government has made it clear that we're going to have something called UK GDPR, and that will take effect on the 1st of January 2021. UK GDPR will broadly follow the same remit and the same focus as EU GDPR, but there are differences. Okay, so the first is it will come into domestic law. It's already lined up. So there's something called the European Union Withdrawal Act 2018. And this is a power that allows ministers effectively to change legislation. And obviously it doesn't affect just data protection. It affects a whole host of other things that will be incorporated into domestic law. Because at the moment, GDPR is a regulation, and as a regulation, it's automatically read into UK law without a UK Parliament enacting it. So UK GDPR will be enshrined into UK domestic law. It will only apply to the United Kingdom and Northern Ireland, and therefore, and here's the thing, it may not be recognised by EU member states. So we've still to learn, and I'll talk a little bit about that in a minute. So what is the difference between GDPR and UK GDPR? Well, there's not a huge amount of difference. The government hasn't agreed on many things with the European Union, but it has agreed that we will have a UK GDPR, and that will mirror EU GDPR. Now, whether there is versions or convergence down the line, we're not sure. But effectively, if you already have GDPR policies within your business, then for many businesses, there will not be huge amounts of change. However, if you are trading with the European Union, sending goods or indeed providing services within the EU, there will be some things that you will need to do and you need to be aware of. And we're going to cover those off in a few minutes. So the European Union makes a decision for third countries in terms of whether their data protection laws meet something called adequacy. At the moment, only 12 countries outside the EU meet something called adequacy. If the EU rules that we don't meet adequacy, then there are safeguards that you will need to put in place to continue to trade safely within the EU. Conversely, if we do meet adequacy, then in many respects it will be a rollover matter, and the UK will be deemed a safe place for personal data for EU subjects to come here. And you might say, well, my business doesn't really have any personal data. But for example, if you run a mail order business and you sell overseas, if you provide services overseas within the EU, and you're collecting personal identifiable information, and that could be as simple as somebody's name, a driving license details, passport details. You can see the travel industry is already going to be scratching its head with this. Then you are collecting personal data concerning EU subjects. And that's where the problem arises. So, and think of it, if you had an overseas subsidiary, and we'll be covering this in a minute, and you wanted the HR records for your overseas subsidiary, technically you can't have those without putting in place certain documentation, which we'll be covering. So this has a wider ramification than many people think. So let's just talk about that adequacy test. So a number of countries have met adequacy. I'm just going to line that over. So New Zealand, Argentina, and Israel and Japan, which is the latest, and Canada, of course, meet adequacy. But you'll note on there, even the even the United States or Australia don't meet adequacy. So it's not a given that the UK will be deemed as meeting adequacy. I suspect, being cynical, that if a trade deal goes through, will automatically meet adequacy. And if a trade deal doesn't go through, they will come up with some reason why we don't meet adequacy. But you'll note there on the screen, ladies and gentlemen, it took Japan 2 years to meet adequacy. And they did have reasonably robust data protection laws there already. So what happens if we don't reach a deal over data protection adequacy? So this will have quite an impact in terms of overseas data transfers. So if you're currently, for example, importing data into the UK concerning EU subjects, processing information, so you could be processing things, people coming to the UK because they're travelling here. You could be processing EU subjects' data because they're purchasing your goods or services. Then there is an issue, and an issue that needs to be addressed. And it's likely you will need to put in place either binding corporate rules or standard contract clauses, or both. You will also need to look at having an EU representative. Now, the good news is the EU representative can also be a UK representative. You don't need to have a separate representative, but you do need to be able to demonstrate that you can respond quickly to data subject access requests, and also, obviously, various other bits of documentation that comes out from this process. So let's just talk about binding corporate rules. So these are valid where you've got it talks here about a legal entity, so they're legally binding. So you have an overseas entity, so your business overseas employs people, and say you want the HR records, or you want some other personal data concerning your employees, then you will need to put in place with your subsidiary binding corporate rules. And if you don't do that, your entity within the EU, not your business in the UK, but your entity within the EU could then face a fine of up to 4% of its worldwide turnover. So these things are to be taken seriously. And of course, some people have already been fined. In the UK, British Airways was threatened with a 200 million fine, but then apparently the Information Commissioner's Office saw its balance sheet and settled for less than 20 million. But nevertheless, these are not things that are fines that you want to be incurring. So binding corporate rules are legally binding, and they enforce the two businesses in the UK and the one that's in the EU to work together to recognise data subjects' rights and to expressly confer enforcement rights on the data subject. So say you had a French subsidiary or the French, and you wanted that data, and there was some personal data within there, the data subjects who are concerned within that personal data are given legal binding rights, and they can hold your business to account. Now, chances are that's not going to happen, but nevertheless, you will need to put in place binding corporate rules. As it says there, covers third countries involved. Third countries, the UK at the end of this year will be classified as a third country. Not a third world country, a third country as far as data protection is concerned in the EU. There's also, as part of binding corporate rules, various things in terms of legal redress. So it allows data subjects to enforce those rights, both within the EU and within the United Kingdom. Standard contract clauses are more commonly used. These have just recently been revised. There's various editions doing the rounds. Obviously, the latest edition will have this year's date on. They were originally drafted and put together by the European Union, and they cannot be modified. And effectively, it runs to about 10 pages, and it sets out within there about upholding data subjects' rights, protecting data subjects, minimizing their risks, etc. The party that is exporting the data signs it, and the party that is importing the data signs it. And it's officially recognised, obviously, by the European Union as a legal way of exchanging data outside the EU. So the model contract clauses, just like the standard contract clauses, the standard contract clauses, just like the earlier contract clauses, the binding corporate rules, impose certain conditions on the parties. And again, they're legally enforceable within both the United Kingdom and the European Union as well. Some big American companies who are in a real mess at the moment, because some of you will remember that during the summer, there was a big bust up with the Privacy Shield, and the Privacy Shield was deemed inadequate by the European Court of Justice. And as a result of that, some companies, I've noticed Google as one of them, if people have got Google Drives, but there are other providers as well. They've actually taken these, the standard contract clauses and incorporated them into their terms and conditions. And that's something you could do as well. And that's an easy hit to deal with it. But there are some other niceties as well in terms of just how those are incorporated in. So if you need help with that, do talk to me. So how does all this stuff affect your business? Well, first of all, you will need to do some changes to your documentation. So your privacy policies or privacy notices or privacy notice will need updating, because it will no longer be, if you've got GDPR on there, it will need to say UK GDPR. Data protection impact assessments will also need updating, because there's no longer a risk, in theory, to European Union subject data, unless you're trading there. So there are some changes to be made there. And there's a few other points within any documentation that references the EU or the European Data Protection Board, which will no longer be valid. So as from the end of this year, the Information Commissioner's Office in the United Kingdom, which regulates this process and a whole host of other things, incidentally, ladies and gentlemen, ranging from the telephone preference service to gambling, well, that department, the overall department the ICO's in, will be standalone. So at the moment, the Information Commissioner's Office reports to the European Data Protection Board. That will end at the end of this year. UK GDPR is purely concerned with the processing of UK subjects' personal data. So it doesn't have a territorial scope covering the EU, but it also incidentally means that the United Kingdom can freely trade outside the EU, where in the past there were certain restrictions in terms of data processing, America being an example, where we had to follow EU rules. That will no longer apply at the end of this year. So how does this affect your business? Well, the first thing is we've covered off the subsidiary side of things. The second point I'd say to you is the whole issue of adequacy. So if we don't meet adequacy, we will need those binding corporate rules in place. Do you trade with companies in the EU and process any personal data? That's a question you need to ask within your business. If you do, then you will need this documentation in place. But what about things like data protection officers? So can continue to share a data protection officer. So a data protection officer can be shared with the EU and the United Kingdom. But, and there are buts, you must make sure that your data protection officer is easily accessible and preferably has some means of conversing in the relevant language of the member state. Again, previously, the European Data Protection Board covered all of this stuff off. Other changes you will need to look at. So basically, you'll need to look at, if you're doing a lot of processing overseas, you will need to look and see which of the EU countries is your biggest customer or client. And you will then need to identify who the lead supervisory authority is, i.e. which country has got the equipment. So each country has got a competent data protection authority, as we've covered already. In the UK, this is the ICO, but in Europe, each member state has got a data protection regime or organization. And if you're doing a lot of business, say with Germany, and that's your main, most of your customers come from Germany, or the majority, then you should choose the German authority as the lead supervisory authority, as well as who your EU representative ideally is based within Germany. But however, if your EU representative is based in the UK, they still need to inform that supervisory authority that they are the representative for your business. So a little bit of fancy footwork around there. I'll talk about that later, ladies and gentlemen, if you've got any particular questions appertaining to that, because it sounds slightly complicated. It's not. Your company's privacy policy, so if you're doing a lot of business in Germany, will also need to name that supervisory authority as well, and also your EU representative. Now, there are things that you will need to be able to make sure that you can properly handle. So if you have an EU representative, you need to make sure that your EU representative can handle data subject access requests, DSARs, within the 30 days prescribed timeframe, because as far as the EU is concerned, if you're trading there and you have an EU representative there, you've got to work within the time frame. Incidentally, it won't make any difference in terms of the UK, because the UK is sticking with 30 days. Now, if you're a big company and you have 250 employees, there are a few other things you need to do. One of the things you should already be doing is keeping a record of processing activities. And that doesn't need to be complicated. It can be a one-page document, simply says what you process, what you do with the data, etc., etc. And for most businesses, that doesn't actually change from a day-to-day basis, but that will potentially need updating at the end of this year. Okay, so let's just talk a little about outside the EU. So 11 of the 12 third countries deemed adequate by the EU have informed the UK government that they will maintain unrestricted personal data flows. So that's convenient in some respects. So Japan, Uruguay, I'm not sure if many people are doing business with Uruguay, but Uruguay applies, but more importantly, places like Canada. So they will treat and they will recognise and acknowledge that the UK's data protection standards meets adequacy, even if the EU doesn't. There's currently no changes to the way UK businesses will send personal data out of the UK, so you can continue, interestingly, to send UK subjects data back into the EU, but it's getting data out of the EU back into the UK where the problem arises. So we can send data to the EU and, of course, Gibraltar as well. So, just to round off, ladies and gentlemen, what actions are needed over the next couple of weeks? Well, we need to monitor to see whether the UK meets adequacy. If it does, it becomes a lot easier. But whether we meet adequacy or not, you will still need to update your documentation, or certainly early January, to reflect UK GDPR. In many cases, that's simply a case of putting UK GDPR on documentation instead of UK GDPR instead of EU GDPR. You need to check what personal data you're bringing in from Europe and to see what other further safeguards needs to be put in place. And the government's also got a very handy website called Monitor What the UK Government is Publishing, and there's guidance online. Very handy. The trouble is the media probably tell you faster that information gets posted on that site. Whew, that's a bit of a whistle-stop tour, I have to say, ladies and gentlemen, but that is the vital information that you need to know. I'm very happy if people want to unmute, if they have any questions, or there is at the top right-hand side a little circle, and you can, if you wish, actually go onto that circle and post questions. So I've got two questions here. So I've got a question here, and I'll just call her by her first name, Kath. What does the EU expect to make? When does the EU expect to make a decision on adequacy? I think this has been the data protection story of the year, and everybody's waiting with bated breath. So we're hoping there's a decision made by the end of the year. The problem is, Kath, that they're actually relying at the moment on some kind of trade deal. This is the EU, and it's a lever. It's a lever to pull or to hold back from agreeing, and it takes the pressure off the UK government. So I think if we walk, which is possible by the end by next week, then we will possibly find we still meet adequacy. That's what we're all hoping, but we may have to wait some time before we find that out. So don't expect to know it by the 31st of December.
Thank you.
Have we got any further questions? Okay, so Eva's come up with an interesting question here. So for a global trading association with members in Europe, what changes do we need to implement in order to be compliant? So there's a few questions I would say here. First of all, as a global trading association, it really depends whether you have a sync. So some trading associations are literally registered as an entity or multiple entities, and it depends where that entity is registered. So a trade association, for example, that has a registered office in the United Kingdom is bound very tightly by the rules I've covered. But if the trade association is registered separately in different member states, then that makes things a little bit easier, because effectively it's just the UK arm that's wanting to process data. But just to cover off the worst case scenario, Eva, if your trade association is registered in the United Kingdom, and even though you're reaching out across the globe and around the EU, you're not registered in those countries, then you will need to make sure you've put in place special contract clauses when you're processing data belonging to EU subjects. I'm happy to have a separate discussion on it because there's a few more questions I'd probably like to ask you. Okay, so we have a question from Anne. Do we need to update our privacy policy before the 31st of December and review again on the 1st of January to reflect the possible changes? So the answer is no, Anne. What I would recommend is that we review that at the beginning of January, when the dust has settled and we see where the pieces land. Nobody will be getting fined or into trouble in terms because the documentation doesn't reflect the changes. When a lot of people I know did panic when GDPR first came out, and the media, particularly trade media, was obsessed with 2% and 4% fines. And sure, some fines have been levelled of that ilk, but the sorts of people who have ended up with those levels of fines have been the likes of Google. Facebook is facing its own problems at the moment. That was actually fined very heavily by the American regulators, and is likely to face a very big fine. They're still deciding on the level of fine in the EU because of the, some of you may well remember, this was all tied in earlier this year with the row with the sharing of data in America, and a company called Cambridge Analytica that's no longer around was processing data belonging to American subjects and then selling it to the Republicans. And that was in 2016. That ended up with a big court action, the Shrimps case. and they just settled on that, and that's one of the reasons that it's no longer safe to send data to America, because the Privacy Shield has failed without other safeguards. Okay, so Danny's asking a question here. Will we get a grace period to update our documentation based on when we receive the decision? The answer is yes. So the Information Commissioner's Office was pretty tolerant last time, and although people didn't have everything in place, what they said was if you could demonstrate that you were in the process of doing things and that you were taking data protection seriously, they were fine. In fact, the ICO came out with I was at a seminar. That's when, in the old days when we went to seminars, and the ICO came up with something very funny, and they said they didn't even think within the first months that they were fully compliant, which made everybody laugh in the room in 2018. But you do need to demonstrate that you're moving in the right place. So if you've already got documentation in place, that's fine. But just bear in mind there are a few things that you should have in place now under the current rules, and you will need under the existing rules. So everybody understands about privacy policy, data subject access requests. Hopefully you've all got forms, or at least the means of responding to those. But suppose you have a data breach, you've 72 hours to respond to a data breach. Have you got a data breach policy? Because if you have a major data breach and you lose a lot of data, the first thing the Information Commissioner's Office is going to want two things from you. A, that you report within 72 hours that you've had a data breach and share what you can with them. But secondly, if you're doing that, it also wants to see what your data breach policy is, and it will most likely ask for a copy of that breach policy. A lot of these policies can run to 7 or 8 pages, so it's not something that you can do over dinner on an evening in 10 minutes. It's a detailed document. Okay, do we have any more questions at all? I've got Anne, I think. I've got Danny. Good. Okay. Well, oh, hang on. Freya, will your presentation be sent to attendees afterwards? The answer is yes, Freya, unless anyone's directly competing against the agency here, which I don't think anybody is who's registered. Yes, we will share that, and my colleague Oliver will send that out this morning to you.
Thank you very much. Thank you.
You're welcome. Anne's asking a question here. Imbri, another one. What should a trade association tell members to look at to ensure they can demonstrate they are looking at the possible changes for UK GDPR? So I think pretty much, Anne, as I've highlighted today, we just need to make sure that privacy policies get updated. But what we'll do as your client, we will liaise early in the new year and have a conversation, and we'll possibly do it. Well, we'll do a checklist for you in terms of what members should be doing. But at this stage, I'd tell you members not to panic. Let's see whether we get an adequacy decision, and then let's do them a checklist at the beginning of next year. And in the meantime, if you want to share some of the information I've shared today, I'm happy for you to do that. And indeed, I'm happy for you to share my presentation with your members. Okay, so Ian's got a question here. Are we likely to see any changes to the UK GDPR? We are, and this is one of the things we're not entirely sure of. So the UK government is committed at the moment to working on the same level playing field in terms of data protection. We think that could change down the line, and the government's already committed to amending the 2018 Data Protection Act. For those who aren't the techie types on this webinar, basically that 2018 Data Protection Act is used to regulate the police, immigration, on all the good things that GDPR doesn't cover. So GDPR doesn't cover things like law and order, border enforcement and other things. Those are all covered under the 2018 Data Protection Act. The government's talking at the moment of it sitting alongside the two pieces of legislation sitting alongside each other, but we think the government may well choose to merge the two pieces of legislation together because it doesn't make a lot of sense to run them separately. But it was all back to member states' competencies on law and order. Member states were not approved to have, well, they were approved to have collective intelligence on law and order, but they weren't allowed, the EU was not allowed to enforce things like law and order. Good. Okay. Well, unless we have any more questions, I will thank you all very much for your time. Okay.
Thanks, Philip. That was fantastic.
All right. You're very welcome. Thank you then.